Okay, thanks, Karen. Morning, everyone. Can I first ask you all to put yourselves on mute to start with? So I'm getting a bit of feedback. And if you can remain mute unless you're speaking, that would be really helpful because it just stops that feedback, that echo. Can everyone hear me? Just nod or thumbs up. Perfect, thank you. So, well, good morning, everyone, and welcome to the second pre-examination meeting in relation to the appeal by Muirdown Energy Limited against the decision by the Highland Council to refuse an application for planning permission for a wind farm comprising of 7 turbines and associated infrastructure, known as Drumholliston 2 Wind Farm, to be located on the Sandside Estate, approximately 2 kilometres west of Ray. As you'll be aware, my name is Trudy Craggs, and I'm a reporter with the Scottish Government's Planning and Environmental Appeals Division, and I've been appointed by Scottish ministers to consider the appeal and to determine whether or not to grant planning permission. This is a virtual meeting and is being broadcast live, and as such will be stored as part of the DPA website archives and will be capable of repeated viewing. By participating in the virtual meeting, you're consenting to being filmed. You're also consenting to the use and storage of those images and sound recordings, and of any images or information pertaining to you contained in them, for webcasting and training purposes, and for the purpose of keeping historical records and making those records available to the public. Further details of our privacy policy can be found on the DPA website. First of all, thanks to my colleague Callum Henderson for arranging today's meeting. Callum will just hide in the background today in case of any technical issues, and hopefully he'll step in if there are any. Please can I ask you to ensure that phones and other devices are not audible during the session, albeit I recognise you may need to contact others in your team if you're not physically in the same room. So can I ask the participants to introduce themselves? First of all, can I ask each participant for the appellant to introduce yourself and those attending today for the appellant?
Good morning, my name is Robin Hutchison, acting on behalf of the appellant, and I'm joined today by Angus Elder, who is from the appellant.
Thank you, good morning both. Turning now to the Highland Council. Could lead participant for both the Council and Nature Scot introduce yourself and those attending on behalf of the Council and Nature Scot this morning?
Yes, good morning, ma'am. My name's James Finley, Queen's Counsel. From Nature Scot, we have Debbie Skinner and Catherine Harry, and from Highland Council, we have Simon Heinsohn and Claire McEwen.
Oh, I've just noticed there that Catherine can't hear anything. Callum, I'm not sure if anything can be done to deal with that.
All I can suggest at the minute is that Claire, maybe just Catherine Harry maybe tries leaving and then joining again. If that doesn't work, it might be just playing about with the audio settings, but I could contact Catherine separately about that.
Okay, you happy to do that, Catherine? Okay, we'll see how that works out. Again, put something in the chat if you can't hear when you come back in. The lead participant for Caithness West Community Council, can you introduce yourself, please?
Hello, yes, it's Gillian Bundy here from Caithness West Community Council.
Morning.
Morning.
And finally, for Rawog, could you introduce yourself too, please?
Morning, I'm Ian Kelly, planning consultant representing Rawog. It's just myself here this morning. Thank you.
Thank you. And just to clarify, are you happy that I call your group Rawog? Is that how you pronounce it, how you say it? Yeah, okay, perfect. Okay, I'll just carry on. Actually, I'll see if Catherine comes in, but I'll carry on.
Ma'am, I would say that we were on a different group chat before this, but Catherine Harry mentioned that she had some connection issues previously. So at the moment, we're happy to carry on, even if she's not in attendance. But I'm sure she will. Looks as though she may have just come back in. I gather Claire Farmer's also had issues as well, but I can hear you loud and clear. So hopefully we should be able to continue. as long as there's a representative from either body in connection.
Okay, thank you for that. And again, if other people have problems, just flag in the chat and we'll see what we can do. So as you all know, I held the first pre-examination meeting in relation to this matter on the 13th of May. And at that meeting, we discussed the procedural arrangements and the timescales, and those were agreed. A note of the meeting was then circulated on the 20th of May, and it was agreed that I would hold a second pre-examination meeting to discuss whether any changes are required to the arrangements for the hearings in light of any easing of the COVID-19 restrictions. The matters to be considered and discussed today are set out in the agenda that was circulated last week. As you'll all be aware, there will be no discussion on the merits or otherwise of the case, and I will not hear any evidence today. I will be keeping a note of our discussions this morning, and after the meeting, the case officer will circulate to all the parties who attended the meeting a note of the key decisions and the key procedural arrangements in the form of a procedure notice. So I thought it would be useful just to summarise progress to date, which is item 2 on the agenda. I carried out an unaccompanied site inspection, focused on the wildland areas and viewpoints during week commencing the 7th of June. Thank you to the appellant for providing walking routes and maps for me, and to Nature Scott for their input too. Thankfully, it was quite nice weather, and it was a nice trip up and a nice walk around. All the further submissions I requested have been submitted, so thanks again for that. Draft conditions have also been submitted, and these are agreed between the appellant and the council. Nature Scott and the Community Council have both commented on these and requested a couple of amendments, one in each case, to them. The statement of agreed matters has also been submitted, and this was particularly helpful and has informed the agenda for today's meeting, in particular item on hearing sessions, which we'll come on to later. And finally, I've received the itinerary for the company site inspection, and we'll discuss arrangements for the site inspection later. So we've made good progress, and thanks for keeping to the timetable so far, which has been really helpful. Moving on to item 3, which is the COVID-19 guidance and implications. Now, as you'll all be aware, the First Minister announced further easing of restrictions yesterday. It is still anticipated that on 9th August, all physical distancing requirements will be lifted, but this is conditional on over 40s being fully vaccinated and a view of the data at that time. If the restrictions are to be lifted or go to some other format, that will be confirmed by the First Minister 1 week before the 9th of August. If she confirms that restrictions are lifted, then the DPA will move gradually to back in-person procedure where that is appropriate. And in line with our current guidance note, virtual procedures already planned will be converted to in-person only where that can be done easily and only where it wouldn't delay the process. So I was thinking, what does that mean for this case? So first of all, thinking about the hearing sessions. Now we have arranged hearing sessions for the end of September and had assumed that they would be virtual sessions at this stage. If physical distance requirements are fully lifted, I just want to explore today whether the parties want to move to in-person proceedings, subject to those two caveats that it can be done easily so that we can find a venue very easily and it wouldn't delay the process, or are parties content to still proceed virtually? So if I can take views on that first and start with the appellant, please.
Well, the appellant's view is that we're content to maintain virtual proceedings if the reporter thinks that's the an appropriate means by examining the case. We're content to remain virtual.
Okay, thank you. For the Council on Nature, Scott, Mr. Finlay.
Our preference and don't have I think I'm not quite just having an exchange of communication offline at the moment on that. Okay, perhaps I can ask you to hear from Mr. Kelly first, and then I can come back to you on that.
That's fine, yeah, if you want to just laser your team. Mr. Kelly.
Ma'am, I'd need to take final instructions in this once the minute of the meeting comes out. As a generality, I think local people would prefer to have face-to-face session, oral evidence sessions, not least because in this part of the country, broadband capacity is not as good as it is in the cities, and tuning in and constantly following virtual proceedings can be quite a challenge in the remoter rural areas. Having said that, we would not insist on it or make a big point of it if other parties wanted to continue with virtual proceedings, but I think I can fairly say the preference, if possible, would be for face-to-face hearing sessions.
Okay, thank you. That's helpful. Ms. Bundy, for the Community Council, do you have a preference?
I would say absolutely likewise with what Mr. Kelly has just said. From local people's perspective, I think there is a definite preference to have face-to-face hearings. That does make a difference. And I know that some of the people who've been trying to listen in on the webcast have had some difficulties. So definitely face-to-face. But whether we wouldn't absolutely push if all the other parties are content with virtual hearings.
Okay, thank you. Now, I'll come back to you, Mr. Finlay, if you're in a position to come back to me.
Yes, I am. I think I'm a slightly split personality. Highland Council is broadly neutral on the subject. Nature Scott, on the whole, would prefer a virtual session given the certainty and other factors. But Highland Council don't have a content whichever way you would decide. But Nature Scott would prefer a virtual session.
Okay, so we're kind of split down the middle then between the participants on their preferences. Putting that to one side just a moment so we can maybe look at that in the context of also what it means for site inspections. Now, we had agreed to do an accompanied site inspection on the 20th September, and this was to focus on the visual viewpoints, the landscape and visual viewpoints, rather than wildland. Now, if we do this virtually, which is what we proposed, the first question I was going to ask the parties is whether that date still works, or would you rather do it slightly before the virtual sessions, so you've got time to go back to your respective offices to do the hearing process. The other question I was going to ask is if we are allowed to do accompanied site inspections, which we may be able to do by that point, would parties want to extend the accompanied site inspection to include wildland? So it's two kind of questions there. So I'll start with the appellant again.
In terms of the timing, we might want to reserve our decision on that until later in the agenda, because I think one of the items is whether we still wish to hold our planning policy and conditions hearing sessions. And I wonder if the view may be that those are not necessary anymore. Certainly that's a possibility, and perhaps trailing our view on that subject now. And that would then free up the 29th. So if we did decide to hold, or if the reporter, sorry, if you decide to hold a virtual hearing, that would give us time to travel back to our respective offices after the day of the site visit on the 29th, which would mean no change needed.
Okay.
On the question of including wildland viewpoints, I think the appellant was content with the current itinerary and approach. I'll perhaps just let Mr. Elder speak if he thinks that actually we should be, we would like to have wildland viewpoints considered at the accompanied site visit.
Given I've been to the wildland area, I think we'd be led by Nature Scott. I think on that point, I think from the statement of agreed matters, I think we put up, agreed a fair bit there, but we've made our position fairly clear. So yes, we're happy to be led by them on that point.
Okay, thank you. Mr. Finlay, are you able to comment, or do you want to take instructions?
I'm able to comment briefly, at least initially. First of all, I agree with Mr. Hutchinson that it looks as though that there may be no need for either of the conditions or the policy session. That would be our preference too. So, so that would allow a free day for people to get back to their offices. It would also assist me because I don't know whether you recall, I am still due to be in court on the Wednesday, which is why those sessions were arranged then. So if they didn't need to take place orally, that would be of assistance. As to the wildland inspections, perhaps I can be as bold to ask Steve, how much of the wildland area or how many of the wildland viewpoints you managed to reach when you were up in early June. There's no point necessarily going back to them, but if you haven't been, I think Nature Scott had a view of going to one or two more than were on the initial proposal.
I did 3 out of the 5 viewpoints. That helps.
That helps.
If it gives you any comfort, I was going to go up slightly earlier to do a little bit more walking around before the accompany site inspection on the 28th.
Certainly, unless I'm told otherwise, I think I think if you feel you've had sufficient view, then that's fine. I don't think Nature Scott requires to have any further accompanied site visits.
Mr. Kelly?
We would not look for an accompanied site visit to all of the wildland viewpoints, but we would prefer that you went to all of the wildland viewpoints and saw them for yourself. And on that basis, we don't see the need for an accompanied site visit to the wildland viewpoints. In terms of the current planned itinerary, we were happy with that, and it may be that subject to COVID restrictions, a local person rather than myself would look to join in the accompanied site visit. Thank you.
Thank you. Ms. Bundy?
Yes, absolutely. We would have someone available that would accompany on a site visit, and I would agree with Mr. Kelly that provided the other 2 viewpoints are covered, we're not overly bothered about the accompanying you on the other 3 if you've already been there.
Okay, that's all really helpful. I mean, I think on that basis, I can then proceed to do the rest of the wildland unaccompanied, which I'll do before the oral sessions. We'll come back to the dates. I think we probably will get to the situation where the 28th of September hearing isn't required, but we'll come back to that. Come back to these dates just shortly. As for the proceedings, I'll have a reflection on that. Part of me is minded to perhaps do it in person if we can, and if we can get a venue subject to those caveats. It will depend on a venue and things like that, and it will depend if the restrictions are lifted. What I was proposing, I mean, I don't think we need a 3rd pre-examination meeting, but we could confirm the arrangements in writing. We commence the 16th of August to confirm in person or virtual. We won't move that date of the company site inspection, we'll keep that to the 28th. So the only thing would be whether we're staying up there for the next couple of days to do the hearing session in person, or whether we'll go back and do it virtually. But yeah, we can confirm that in writing that we commence on the 16th. And that'll just confirm the arrangements and the process going forward. Would everyone be happy with that approach?
Would it perhaps assist if the appellant got in touch with I think we talked about the way in being a potential venue?
We have made contact with them. We can't book anything at present because we're not permitted to because of the restrictions. But we have made initial contact with them. I don't know if Thursday was busy that time of year at the end of September. If we need to come back with alternatives, I'll get in touch with the parties if there's any alternative locations, if that happens to be unavailable at that point in time. Okay, so moving on to item 4, which is additional environmental information. Now, in the statement of agreed matters, it's at paragraph 5.30, states that the appellant will invite the reporter's request additional information for the purposes of the hearing sessions to update the cumulative assessment contained within the EIA report. Now, I'd just like the appellant maybe to give a little bit of background to this and explain what you're proposing.
Yeah, absolutely. So to take account, as you say, of the updated cumulative position in respect of those, the change in status of those 3 schemes, we're proposing to submit updated cumulative wireframes for all the landscape and visual and wildland viewpoints, cumulative ZTVs for Drumholliston 2 and the 3 schemes, and a short assessment of any implications in terms of the significance of effects as a result of that information.
Okay. I think it would be useful from my perspective, and I had actually had the same thought when I was out walking around the wildland. Funnily enough, and I saw the statement of agreed matters and kind of reflected on my own thought was as I was doing my site inspection. We'll ask the parties to comment on this. Start with Mr. Finlay for the Council on Nature, Scott.
I think that suggestion sounds sensible. There's also a variation application to Limekiln 2, which may need to be considered. I don't know whether that may already have been done, but there's a variation application to Limekiln 2, and the Strathy South variation. There's a slight change in status in that, and that the Highland Council have had a committee report and taken a decision to project the increase in height, although Mr. Heinsohn can correct me about that if I'm wrong. I don't think there are any other significant changes, but in general, in agreement.
Mr. Kelly.
The cumulative position is quite complex and it is changing quite rapidly, especially if you consider scoping schemes. We would suggest that the updating of the cumulative landscape and visual impact assessment information is a very good idea. We would suggest that it needs to include the wildland viewpoints as part of that update. We would look to the Council and Nature Scot to confirm and agree a list of schemes that form the additional schemes to be assessed, and we'd like to see that list. And finally, I have a slight concern about the timescales because I don't know when this material will be circulated, but currently the hearing statements are due on the 2nd of August, and I very much suspect we will not have enough time to consider properly that updated material before the 2nd of August. Thank you.
Thank you. Before I come back to the appellant on that point, Ms. Bundy, do you have anything you want to add at this point?
Nothing to add. Thank you.
Okay. Turn to the appellant. The point I was also thinking about the timescale and what your proposal for that would be, because obviously we do have hearing statements coming up, and just thinking how that would fit in the process. Also, if you want to come back on the scope and whether variation of Limekiln 2 should go in, are there any others that should be factored into the assessment?
That's fine. Number of points there. I'll try and remember them all. Starting with Mr. Kelly's, yes, we can confirm that the wildland viewpoints will be updated. So I agree with you there. That's a yes. In terms of the projects to be included and the list, that was something that was discussed between, as you suggested, between the appellant and Highland Council, and that list is agreed in the Statement of Agreed Matters that is currently before the inquiry. In terms of timescales, and we've got a separate bullet on this, and I should just forewarn you've got a question of process to mention as well. But in terms of timescales, we were proposing Friday, 23rd of July. Our landscape and visual consultant is on holiday next week, but if we're agreed on the scope, can move quickly and turn those around for Friday, 23rd of July, which appreciate doesn't give a huge amount of time, but gives it a couple of weeks, and obviously there will be also rebuttal statements and then the opportunity for oral evidence. So there will be a number of opportunities. The hearing statements will not be the full and final case. Turning to Mr. Finlay's points on the updated or the changes to Limekiln and Strathy. I mean, it is of course the case that these schemes are moving feast. I think on Strathy the position is that the council has resolved not to object to the scheme if 4 turbines are removed. Obviously this is outside the scope of this inquiry, but as I understand it, it's a bit of a moving feast still as to what's happening there. I do think that the parties agreed a cut-off date for cumulative information in the Statement of Agreed Matters of the date of submission of the appeal. So I think we agreed that that's the sort of the appropriate balance to say, well, let's draw the line here and proceed to assess things as they stood at that point. I think that's been agreed in the Statement of Agreed Matters, and as far as I'm aware, both the changes to Limekiln, which actually I'm not aware of, but I don't think we were aware of that having occurred before the cut-off date, and likewise the Strathy changes are very recent. So I would propose that we just stick with that cut-off date, but we will double check the position on Limekiln variation. Have I covered everything?
You have, from my perspective. I'll ask Mr. Finlay if he's got any other comments he wants to respond to there.
No, I certainly didn't mean to go behind what was in the Statement of Agreed Matters as to the cut-off date, because that's clearly a sensible arrangement. But if there is an update on Limekiln, I thought that might have predated that, but that's just from involvement in another inquiry. As to the date of production of the material, because of leave arrangements, it would be helpful to us if we could have the wire lines even a couple of days earlier than the 23rd. Just that would be the last day. I think Catherine Harry's set aside for this before she goes on leave. So if it could be the 21st, for instance, then that would assist us in that regard.
Okay, thank you. Mr. Kelly?
I need to go back and look at the Statement of Agreed Matters, which of course we were not signatories to. And of course it contains matters that are not agreed, so it's a rather strange thing to call it Statement of Agreed Matters. The timeline would be very, very tight for RAWOG to consider this material and still get a statement in on the 2nd of August, but I just leave it with you that it's going to be incredibly tight. On Strathy South, I'm not aware of any recent change to the Strathy South variation. It was proposing 200 turbines. When the council gave its response to Strathy South, there was no further variation scheme minus the 4 turbines. So we are assuming that the council's position is one of objecting to the scheme in which they were consulted. And it will also be for Scottish ministers to decide what to do. But I think the Strathy variation remained at 200-metre high turbines, and so that should be included within the updated cumulative assessment. But otherwise, I'll go back and look at the Statement of Agreed Matters, and I'm quite comfortable with the concept of there being an agreed cut-off point. That's perfectly normal. Okay.
Ms. Bundy?
Yes, I think we would request at least the Limekiln variation be included in the updated cumulative assessment. We recognise that the situation at Strathy has moved and changed, but in terms of impact for the Way area, the Limekiln variation is of more significance for us than Strathy.
Okay, any final comments from the appellant on this, Mr. Hutchison?
Yep, absolutely. And Mr. Elder is going to make a comment as well. Perhaps I could talk to him first.
If I could just add, I'm aware that the Limekiln 2 variation is at scoping stage at the moment, and I'm also aware that there's a legal submission from the council in terms of including that in the Limekiln 2 extension in the assessment of that. That seems very muddy to me in terms of including it at this stage in our appeal. Well, given it's clearly not agreed even for Limekiln 2 extension, whether it's being considered. So I just add, I think that's probably worth considering in the background for us to include it at the scoping stage right now and to do a full assessment of that scheme when it could well change when it comes to application stage. So traditionally, I think we have to treat that like any scoping application, if that's fair, I'm afraid.
Perhaps perhaps we could follow with a short written submission on the specific point of the variation to Limekiln and just its status, given that I think we're probably a little unsure today, but it sounds as if it post-dates the cut-off date, which Mr. Finlay and Mr. Kelly have agreed is a concept which they are amenable to. So hopefully that will settle that. And just to clarify Ms. Bundy's question, Limekiln 2 extension will certainly be included. That's the proposal, as will Strathy South. In terms of the request to move the date forward, yes, I think we can accommodate that. So that would move our proposal to submit the additional information to the 21st of July. And just in terms of Mr. Kelly's point on timing and it being tight, again, sort of jumping to the end of the agenda and AOB, we will be requesting that we move the deadline for hearing statements 1 week to the 9th of August to accommodate holidays, if others are amenable to that and the reporters are amenable to that. So just an early heads up that would perhaps solve some of the compressed timetable issue that Mr. Kelly raises.
Okay, that's helpful. It would be helpful if the status of the Limekiln variation could be clarified with reference to the... Sorry, Mr. Finlay?
I was going to say, perhaps I can assist in that because myself and Mr. Heinsohn appeared at the recent Limekiln extension inquiry, and that there certainly were wire lines and produced for the Limekiln variation, which is an increase in height of the turbines on the permitted Limekiln. There were legal submissions made, but not by the council, but by, I think on behalf of Caithness West Community Council, by Mr. Campbell. And as I recollect it, they were on the basis there was insufficient information. But I don't think those legal submissions have any impact would have any impact on our inquiry. But just to say that there was Limekiln increase in height, Limekiln 2 plus was sufficiently fixed to be taken into account at the Limekiln extension inquiry. So whilst I'm not seeking to resolve from specifically from the generality of the agreement and the statement of agreed matters, there may be some force in dealing with that for you to have that information, albeit it is only, I think, at application stage. but Mr. Heinsohn can correct me if I'm wrong as to that.
Yes, just to clarify, in terms of the Limekiln variation application, we understand that application is going to be made to the Energy Consents Unit this week or next week. And just following on from the discussion on Strathy South as well, the council did indeed effectively object to the Strathy South application unless 4 turbines were removed. And the applicant has discussed this now with Energy Consents Unit, and further environmental information will be submitted with the removal of the 4 turbines that the council requested, and that will be subject to consultation in due course. I believe that submission is going to be made by the end of July.
Okay, that's helpful. You're saying your information would take account of the Limekiln 2 current application. Bearing in mind what I've heard, is it possible to take into account Limekiln 2 plus with the higher turbines?
I need to
Must be-
defer to Mr. Elder on
Mr.
that.
Elder, yeah, I wondered if it was Mr. Elder.
I think we can proceed on the basis that the application is identical to the scoping, which is not always certain. But waiting, I'd be worried if we delayed any further. Obviously, that has an impact as well. So we can proceed on the basis that the application is the same as the scoping, and maybe you can check with Infinergy, the developer there, that is the case. But yes, we can include that in the community of white lines.
I think that's a fair assumption to make, that the application would be the same as scoping at this point in time. It's the best process to best assumption to go on it, I would say, at this stage. I think that'd be helpful if you can do that. As for slipping the date for the hearing statements from the 2nd of August to the 9th, Mr. Finlay, how would your team feel about that?
Yeah, I don't think, as far as I'm aware, that wouldn't be an issue. No, I don't think that would be an issue for us. So that works. That would work for us. I think there's sufficient scope in the timing, given their hearing statements, that we should be able to deal with that.
Mr. Kelly, would that help, Rawog?
Yes, ma'am, it would help. Would you also be looking to change the date for rebuttals by the same period of an extra week? I flagged that up just now because it might be, if you decide to dispense with some of the hearing sessions, that the rebuttals actually become even more important than they are just now. So I would suggest that it would be appropriate, if you agreed, ma'am, to change the date for rebuttals by an extra week as well.
Okay, Ms. Bundy, how would the change in the dates affect you?
We'd be happy with what's proposed.
Just looking at the timeline, so we'd be looking at rebuttals the 30th of August. From the first pre-examination, my recollection is that the dates for the draft agenda to be issued were done to help Mr. Finlay, who's got a previous commitment for a lot of September. So I wouldn't want to move those dates, because I think it perhaps would be unfair to the council for their preparation. But I'm prepared to go with give an extra date for the rebuttals and have a shorter time to prepare the agendas, if that would help the parties. Ms. Hutchin, is that be acceptable to the appellant?
We're happy with that. The only reason we hadn't suggested moving the rebuttals was not to squeeze your time, but that's your decision to take, of course.
Just trying to get it work for everyone. Mr. Finlay, would that work for the council?
Yes, I believe it would. Thank you very much.
Okay, so I think on that basis we would move the hearing statements to the 9th of August. and rebuttals to the 30th of August. And the other dates would remain as they are. Ms. Hutchin, you indicated you had a question on process for additional information, which is probably what I'm going to come on to, but I'll let you ask your question or raise your point.
Yeah, absolutely. It's just in terms of the process for advertising. So our expectation is that the additional information will be requested by yourself, ma'am, in the note of this meeting. So it would fall into that category of supplementary information under Regulation 26, as requested by the ministers. Which brings us to the question of advertising and whether it's necessary to have a sort of twin track where we advertise on the publish on the DPA website as part of this process, and separately advertise following the EIA regs as well. And I think that takes us to, with apologies for bringing up the minutiae of the EIA regs, but I guess it's important that we are all on the completely transparent and on the right foot here. But it brings us to Regulation 27.2 of the Town and Country Planning EIA regs, which tells us that there is no need to go through the separate track or the additional track of advertising under the EIA regs, where information is being provided for inquiry and has been publicised, which of course will be happening here. But I suppose the question that may arise is, are we having a quote unquote inquiry, given that actually we've decided not to have any inquiry sessions and we're proceeding by hearing sessions? I raise this for full transparency. You know, we are content, or the appellant is content, that 27.2 applies and that this is inquiry is intended as a catch-all, and we are part of a inquiry process where the information will be publicised on the DPA website. But we wanted just to flag the point, lest it occur to anyone looking at this after the meeting and have an alternative view.
I had looked into this as well, obviously there was additional information, and my understanding was that 27.2 would apply. We have interpreted that if information is provided for the person of inquiry, that would include a hearing session, and we've done that in other cases. I would request the information in the note of this meeting, which is the procedure notice, and we would publicise it on our website. I will ask other parties if anyone disagrees with my understanding, and I was happy to proceed on that basis without twin tracking it with other advertisement obligations. But if anyone's got any objection to that, Mr. Finlay, are you happy with that approach?
Yes.
Mr. Kelly?
It's not an objection as such, ma'am. It's a decision for you to make. I would simply say, representing local interests, that it's wrong to assume that the only people who will be interested in the updated cumulative landscape and visual impact assessment are those taking part in the inquiry. For notwithstanding the legal position, which I accept, the preference of RAWOG is that this should be advertised on a twin tracking basis, but that is not a legal submission to you. The legal position as set out is correct. This is just a preference to ensure full transparency within the local community. And I would not see that process of advertising in any way interfering with the planned timetable for the appeal.
Ms. Bundy?
I would obviously agree with what Mr. Kelly has said. I think in the interests of transparency and making sure that people are as informed as possible, then yes, we would like to see it advertised.
I'll come back to you, Ms. Hutchinson, and how we think about this. But Ms. Hutchinson, any final points on this?
No, just to say we entirely agree with your analysis as set out, and would just point out that, of course, it is going to be publicised on the DPA website, so all members of the public will have access to that. So it's not a case of not publicising the information either way. It's just whether we double up on the process.
Okay, I will reflect on that, because I think transparency is a fair point, and there are a number of objections and letters of support, to be fair, to the application. So I'll confirm that in the note, which I will get out at the start of next week on the basis that the information is coming in on the 21st of July, which is next Wednesday. Okay, so I think we've covered additional environmental information, unless anything anyone wants to add. Doesn't look like it. Okay, so moving on to item 5, which is the hearing sessions. So at the first pre-examination meeting, we agreed that I would hold 4 hearing sessions. Session 1 was planning policy, session 2 was conditions and planning obligations, session 3 was impact on wildland area 39, and session 4 was landscape and visual impacts. So where are we now? Well, in my view, the conditions are more or less agreed, and my understanding is the parties do not consider there is any need for section 75 agreement to do with planning obligations. Nature Scott and the Community Council did comment on the conditions, but I think I have enough information on that to not require a hearing on conditions or planning obligations, which was scheduled to take place on 29 September. Are the parties content that we dispense with that hearing? And I'll start with the appellant.
Yes, we're content with that.
Councillor Nature Scott?
Yes, we're content.
Mr. Kelly?
Yes, content with that.
And Ms. Bundy?
Yes, that's fine, thank you.
Okay, that's really helpful. Given the content of Statement of Agreed Matters, my understanding when we reviewed that is there is broad agreement on the planning policy guidance and the renewable energy context. And it seemed to me from looking at it that the issue between the parties was about weight that it should give to the policy and related targets in making a planning balance. I'll ask if you think my understanding is correct, but if that is the case, again, I felt this was a matter that could be dealt with through closing submissions rather than through a hearing session. So again, I'll ask the parties' views on that, and I'll start with the appellant.
Yes, we would broadly agree with your assessment that there's 1 or 2 specific sort of technical points that we might want to seek, or we would want to seek to draw out, but it is largely a question of weight. Our view is that we're content not to have a hearing session, but we would like to maintain or have in place written submissions in addition to closing submissions. And we think it would be of assistance to see the parties' positions in advance of the landscape and visual hearing sessions. Sorry, the parties' positions on policy in advance of the landscape and visual hearing sessions, because I think one does inform the other to an extent.
I'd accept that. Mr. Finlay?
I agree with Mr. Hutchinson, primarily because we'd quite like to know what they're going to be saying about any policy matters before we get to closing submissions. Some form of sequential exchange of written submissions would be very sensible. They'll clearly be limited in scope, and our suggestion was going to be that the appellants went first, and then the council, and then the other parties, and then the appellants had a right of response, and then we'd have closing submissions following that. That would be a far more effective way of dealing with such, I imagine, limited matters that remain outstanding, and or that Mr. Hutchinson or indeed the council may wish to give particular emphasis to.
Okay, thank you. Mr. Kelly?
I'm always slightly reluctant to forego the hearing sessions on policy, but I also need to have clear regard to RAWOG's limited resources. I think in the circumstances of this case and looking at the agenda in advance, I had concluded that we should be able to deal with the policy issues by way of the original concept of the hearing statement, a rebuttal, and then the closing submissions. So I didn't seek different dates or different processes. I think we could deal with this. I would agree that we could, in this case, suspend, do away with a hearing session on policy and deal with it by way of what would have been the hearing statement, a rebuttal, and then a closing submissions. But there certainly needs to be exchanges before we get to the closing submissions stage. Thank you.
And Ms. Bundy?
I think what I had said in regards to policy was that the Community Council has, we don't have experts in that regard, and we don't have the resource to engage experts. So I think we will have to, we will be happy with what Highland Council puts forward in that regard. And Mr. Kelly.
Okay, so I think there's two options there. We stick with a hearing statement, rebuttal, and closing submissions, or Mr. Finlay suggested the appellant puts in a written submission, the parties respond, the appellant has a right to reply, so to speak, and the parties do closing submissions. I will go and reflect on that and think what would be the best for me to get the information I need, bearing in mind it is quite limited, the points that we're looking to discuss in the written submissions. But I think on that basis we can agree that we don't need to hold hearing session 1, which is on planning policy, which is also on the 29th of September. So that being the case, there will be no hearing sessions on the 29th of September now. Everyone happy with that? And I'll confirm in the note which process I want to adopt on the policy. Okay, so moving on to wildland. Right. Again, I just wanted to discuss the need to hold a hearing in relation to the impact of wildland area 39. Again, given the content of the statement of agreed matters. Now note that paragraphs 523 to 527 are agreed with Nature Scott. And I recall from the first pre-examination meeting that it was suggested that this matter could be dealt with by written submissions, given the terms of a previous inquiry report and the fact it was considered by previous reporters. But it was felt, I think this came from the Council on Nature Scott, that given the importance of the matter and the fact that new guidance had been produced since the last inquiry, that we should proceed to a hearing session. And that's my understanding of where we got to at the first pre-examination meeting, and we therefore decided to have a hearing session on wildland on the 30th of September. Now, paragraph 5.26 of the Statement of Agreed Matters states that the conclusions of the wildland assessment would not be materially different using Nature Scott's latest guidance. But then 5.27 states that the parties still think it requires to be considered at a hearing session. So take this all together, what we said at the first pre-examination meeting and the position in the Statement of Agreed Matters, I just wonder if the parties do think we need a hearing session, or if it's a matter that could be dealt with by written submissions. Before I give my view, I'll ask the appellant to comment on that, given the terms of the Statement of Agreed Matters.
Yeah, we agree with that analysis and don't feel that a hearing session is necessary. I mean, we don't consider there's going to be much technical discussion that takes us any further forward. It's about weight to be placed on this now, and certainly there's no substitute to, as others have said, getting out there and sort of seeing it for yourself, which to the appellant's view is the most important thing here, rather than having a hearing session. So we would be content with written submissions or whatever process is most helpful.
Mr. Finlay.
Nature Scott remain in the view that they would consider a hearing session is important. Number of points to make. Firstly, that the agreement in 526 relates to the fact that the environmental impact assessment was done in the draft of what is now the current guidance, and so it's making it clear that although the draft and the current guidance are slight changes, the outcomes or the conclusions would not be materially different. One of the reasons we requested a hearing on this was that is not the case with the previous reporter's decision, because they didn't use that draft or even an earlier draft. One can go back in their evidence and see that they were concerned about using draft guidance and used an earlier approach, so that the reasoning, that strand of the reasoning why we requested a hearing session remains and is not overcome by the agreement in 526. The second point is that we've already started reviewing the evidence that we would put in the hearing statement. There are matters of disagreement between the parties. I noted Mr. Kelly on said that there are areas of agreement or disagreement in this. To my mind, statement agreed matters can also be very helpful in identifying areas of disagreement as well as agreement. But there are areas of disagreement. I think at the moment, and this is just a tentative view, over cumulative impacts and the approach to that, and the extent to which you should have regard to the previous reporter's views. So that in our submission, there is a purpose in having a hearing session. It may be shorter than would otherwise be the case, given the sensible agreement that has been reached. And indeed, we're not after a lengthy hearing session, and indeed that's primarily in your gift as to how long the hearing session is. But certainly at this stage, we consider, for the reasons we've already indicated at the last PM and those I've just advanced now, which I can elaborate if necessary, that this is a significant, important matter, and that it would be wrong at this stage to shut off the prospect of having a hearing session. We submit that there should be a hearing session. The extent of that will obviously be a matter for you when you set your agenda. And we can then comment, a draft agenda, we can then comment on it, and then you'll set your final agenda. It may be a shorter session than usual, but there are matters that we wish to raise and deal with, or at least have the prospect of dealing with all of them.
Okay, thank you. Mr. Kelly.
Rawag would support with what Mr. Finlay has said, especially bearing in mind that we don't yet have the updated new cumulative landscape and visual impact assessment for the wildland. So even though Rawag would not be looking to make extensive contributions, we would support what Mr. Finlay has just said.
Ms. Bundy for the Community Council?
Yes, nothing to add to any of that, thank you.
My own thought was that given that I'm doing unaccompanied site inspections of the wildland, I still thought it would be beneficial to have a hearing session, because there might be things that I note when I'm wandering around and in the context hearing statements that I feel would benefit from a discussion. But I'm really grateful to Mr. Finlay for just clarifying that point there in the guidance. So I think on that basis, we should still proceed with the hearing session on wildland. So that would be still the 30th of September, which is the first session on that day. Right, so turning to the hearing schedule, session 4, which is landscape and visual impacts. There's no doubt I need to hold a hearing session on this. That doesn't change, like the statement of agreed matters. But really, I wanted just to touch on some of the scope of the session. And this was again given the terms of the statement of agreed matters. And I noted in the agenda the points that I picked out. The first one is in relation to reversibility and the comparisons to the previous scheme. Now, I note that 5.2 states that the parties agreed that the methodology employed in the assessment of landscape and visual effects generally follows good guidance, practice guidance at the time of publication. But I felt that what regards we had to reversibility and comparisons to the previous scheme, particularly in relation to significance, are still relevant matters. They're raised by the council and also by Rawag, and I felt that was something that's still required to be drawn out as part of the hearing. And I just wonder if parties agreed with that, or if the statement of agreed matters was meant to kind of suggest that that was now an agreed point on those 2 points. So I suppose the I'll come to Ms Hutchinson first for the appellant.
I think on reversibility, we're likely all to be agreed. I understand from our landscape witness that the reversibility or otherwise of the scheme isn't a factor in the methodology that we use. So, and obviously that's in line with the direction of SPP. So I think we're agreed on that, although we're obviously happy to clarify the point in the hearing statement. In terms of comparison with the previous scheme, yes, agreed, that should be part of the matters considered in the hearing statement. Obviously, we are assessing this scheme against a baseline of nothing, because that's what's here, and the previous scheme was refused. But we will be seeking to draw out the relevance of the reporter's decision in the previous scheme and how the matters raised in that refusal have been addressed by this scheme, which we do consider to be material to this decision.
Mr Finlay?
I think I would broadly agree with that and have nothing to add.
Mr Kelly?
Nothing to add, no.
Okay. And Ms Bundy?
No, nothing else to add, thank you.
Okay, that's helpful for that one. Then there's a comment again at 5.2 that just the council noted that access tracks have not been included, and they consider them to be highly visible from particular viewpoints. And again, I thought I assume this was something that would be drawn out in the hearing statements in the hearing session. Mr Finlay, I'll come to you first on this one.
Yes, as I understand our case, we're not asking for further visualizations or the like. It's just a point that we wish that would be drawn out in the hearing statements, and no doubt responded to appropriately.
I'll just come to the panel. I'm assuming, Ms Hutchinson, you've got no objection to that being part of the scope of the inquiry or hearing session?
That's exactly how we'd read it, and that was our intention. So I agree with Mr Finlay.
Okay, Mr Kelly or Ms Bundy, do you have any comment on that? No, okay. Right, and then the next point was relation to paragraphs 5.16 and 5.17. And I just wondered what you wanted me to take from these paragraphs in the context of the scope of the hearing session. And paragraph 5.16 states that effects on landscape character were not identified as reason for refusal, and paragraph 5.17 states that effects on seascape character were not identified as a reason for refusal. Is there a suggestion that should not form part of the scope of the hearing? I'll come to you, Mr Hutchinson.
Yeah, well, yes, I mean it's of course your decision, and we would acknowledge that RAWOG are not a party to the statement of agreed matters. It's between ourselves, the Council, and Nature Scot, but certainly we wouldn't intend to address matters which weren't part of the reason for refusal in any detail, and that as was apparent to us in the report of handling and is as confirmed in the statement of agreed matters, landscape impact and skiscape impact are not the reason for refusal, not the particular concern. The concern is visual impact, and I read the caveat about the relationship with the coast and cliffs to be a reminder that there's a particular emphasis on visual impact in relation to coastal views and views along that coast.
Okay. Okay, Mr Finlay.
There are two matters that the statement of agreed matters highlight where there are differences between the parties. One is the one that Mr Hutchinson just referred to, the relationship with coast and cliffs. Also at 5.14, the council consider that there will be a landscape, an impact, a significant landscape effect on the high cliffs and sheltered bays LCT. But as with our objection to the first from Holliston, ours was not a we didn't have a landscape objection to that. We did provide some landscape evidence to set the context for our visual impact evidence. Obviously, any decision maker has to take into account both, and it's often said by those proposing wind farms that all, and correctly so, that all wind farms will have significant landscape impacts. In this case, it's not the landscape impacts that have caused the council to object, it's the visual impact. But those landscape impacts form part of the holistic picture that you have to assess. In our view, the two matters that I've drawn attention may be matters upon which you would require some assistance so that you have the full picture against which to make that assessment. So we don't suggest that landscape should be excluded, nor do we suggest that it will form a significant part of the material before you. But in our submission, there should, notwithstanding these agreements, there are still matters on which, particularly given the previous reporter's views, on which you may wish to have some background evidence to inform your conclusions.
Okay, thank you. That's helpful. Mr. Kelly, do you have anything you want to add at this stage?
No, ma'am, nothing further to add. These are issues that you will have to consider. I suspect that Rawal's comments will be limited to coastal views as such and views along the cliffs. But basically, I agree with what Mr. Finlay has said.
Ms. Bundy?
Yes, we would agree with that. Thank you.
Okay, and the final point that I listed there was residential visual amenity, and the statement between matters, which I know RAWOG are not signed up to, states that this is not a determining issue and does not require consideration as part of the hearing session. And again, I just want to explore that and understand the parties' views on that. I'll start with the appellant, please.
Yeah, we consider that in terms of residential visual amenity or residential amenity impacts at individual properties, you know, such that they would fail the lavender test, as it's known in some circles. It doesn't appear to be part of the council's objection. I don't think the previous reporters found that there was a residential amenity impact at any individual property. So so we would not seek to dwell on that, certainly in our hearing statement, unless we're directed otherwise. Of course, that's quite separate from the views from, for example, Ray Village, which of course we will address.
Okay, Mr. Finlay?
In our view, it doesn't need to be part of the hearing session for the reasons recorded in the statement of agreed matters, and we won't be proposing to produce any evidence on it. And I echo Mr. Hutchinson's caveat that obviously views from Ray and other settlements will be of considerable importance, but it's not a residential amenity whereby the impact on a residence would be such that it would be effectively uninhabitable.
Mr. Kelly?
Thank you, ma'am. I'll defer to Ms. Bundy in terms of the consideration of individual residential properties. From Rawal's perspective, I would agree with what's been said so far. It's important that the views from settlements, including Ray Village, is addressed in this hearing session. But Ms. Bundy may have something to say on individual properties. I know that the Community Council will be concerned about the cumulative effects on properties, but I'll hand over to Ms. Bundy on that.
Thank you. Yes, I'm sure you won't be surprised to hear that our view is somewhat different. We recognise that the council didn't object on the basis that residential amenity would not impact individual properties. The people who live in those individual properties, I would expect beg to disagree. And from the village as a whole, then clearly it would have a very significant impact on our visual amenity.
Ma'am, can I interject here?
Yes, you can.
I wonder if it might help you if I assisted the Community Council, and in their initial hearing statement, if it was felt that there were individual properties that had to be considered, those properties could be listed in the hearing statement, and then parties in the rebuttal could set out their views on whether individual properties need to be looked at. I think that in some way we need to try and assist you by formalising as best we can the concerns of the Community Council in relation to individual properties. And it's just off the cuff, I suggest that we might look to include a list in their hearing statement, and I would help the Community Council in that specific regard, if that would assist.
Ms. Bundy, do you have anything you want to add to that? Would that help?
That would be helpful, yes. Thanks, Mr. Kelly. Thank you. We do have.
Sorry, Ms. Bundy.
There are some specific properties that we would have in mind, but also generically from certain viewpoints in Ray, we would want to make sure that residential amenity was not forgotten in all of this.
Ms. Hutchinson, you're going to come back in there?
I would, if that's okay. Just to say, it feels very late in the day to start identifying individual properties. And of course, just for clarity, as Mr. Finlay summarised and set out, the specific topic here is there an individual property where the impact of the scheme is so overbearing that it becomes an unpleasant place to live or uninhabitable, as Mr. Finlay says, that sort of niche test, which hasn't been raised so far. The previous reporters didn't find this to be the case, and so suggesting we introduce and consider that now feels late in the day, and perhaps not warranted. But to give some reassurance in terms of what we do think needs to be considered. Obviously, the residents of Ray are a very important receptor of visual impacts, and their experience moving through the village and moving on their daily lives will, from their homes, be of course something that we do look to consider. It's just that we feel it's late in the day to start identifying and considering individual properties specifically, like when this hasn't been something we've looked at before or has been felt necessary to look at before.
Okay,
Perhaps,
yeah, Mr. Finlay?
sorry, perhaps I was going to add two matters, just to agree with Mr. Hutchinson, but to reassure Ms. Bundy that it's not that the council doesn't suggest there are significant impacts on residential amenity. It's just the level to which those impacts may reach. So it may well be of assistance to you for properties to be pointed out as sample properties from which to assess residential amenity impact. But I don't resolve from our previous position that in our view, none of those impacts reach such a stage that of themselves the property would become an unpleasant or uninhabitable place to live. So I think Mr. Kelly's offer of assistance would, who's very familiar with the lavender test, may assist in that regard, and you can see whether it is suggested indeed that any property reach the level of impact that would require such a consideration.
Ma'am, can I just say that, just for clarity, I don't think either RAWOG or the Community Council will be looking for updated assessments as such as in terms of residential visual amenity assessments for individual properties. It may, in the end of the day, just come down to a suggestion of a few properties, a few individual properties that you would be asked to visit to view the wind farm site from there. But I will certainly look to assist the Community Council as best I can to make sure the issue is very clearly identified in the initial written submission, so there's no doubt as to what the issue is from the Community Council's perspective, and parties can then respond. But I do not see the need at all, nor are we looking for any additional environmental information or any additional assessments as such on this matter.
Okay, that's helpful. I'll come back to the panel for any final comments you want to make on this point, if there's anything.
I mean,
I think that, sorry, can I make a final point?
Of course you can, yes.
Yeah, I think we do absolutely appreciate that in terms of the official guidelines on the lavender test that was referred to, we accept that no individual properties are impacted based on that test. I think the frustration with the community is that one of the original, or two of the original reasons for Limekiln being refused the first time around, one was wild land, which we obviously agree with, and the other one was the impact on the North Coast 500 tourist route. So I think from a local perspective, we just felt frustrated that tourists were given a higher weighting than the local people. So in terms of residential amenity and the impact on our community, we would just like to be afforded the same respect as tourists, and for that to be properly considered.
Okay, thank you, that's helpful too. Mr. Hutchison, any last points?
Just to say that there were, of course, with respect to Ms. Bundy's point on the local residents, there are agreed viewpoints already from Ray, representative of the viewpoints that would be experienced by local residents, and we do intend to fully address those in our hearing statement, and certainly won't be suggesting they are subservient in any way to the camper vans on the North Coast 500.
Okay, thank you.
Okay, I'm going to reflect on all that. There's quite a lot in there. So I'll reflect on that and I'll clarify in the notes meeting how I think this should be dealt with and the scope. But that's been a good discussion, so thank you for that. That's clarified points. Anything anyone else wants to add in relation to item 5? Nope. Okay, we'll move on to item 6, which is the site inspections arrangements, which I think we've probably covered. We're going to stick with the 28th of September for the company site inspection. Thank you for the itinerary. I note that parties have generally agreed to that. I was going to suggest that we, as suggested in the itinerary, we start at viewpoint 5 and we meet there at 9:30. Would that work for everyone? I would propose I drive myself around, not share cars with anyone. Obviously the parties can make their own arrangements. I'm happy for obviously members and residents of Ray and the area to come along, although I think we should keep numbers tight given the current circumstances, and it'd be helpful to know who would be attending for RAWOG and the Community Council, just from a health and safety perspective and minimising numbers. I'll put that in the notes meeting as well if you can confirm who would be attending. I mean, that's in due course, it's not urgent for just now.
So just from the appellant's perspective on just the logistics of numbers, that's welcome, because some of the viewpoints there are obviously just a limited number of parking spaces, and
yeah, some of them are quite tight.
It was that there was not a huge amount of room.
Yeah, I've got obligations since I'm conducting the site inspection to make sure people are safe. And I don't want necessarily cast thousands turning up where things aren't safe and you can't stop your cars and people can't get out and things like that. It just cause a bit of a hazard, which would be great. Okay, item 7 then. I'd included in the agenda the dates that we'd agreed, and I will update that list when the notice meeting comes out. We've moved the date for hearing statements to the 9th of August, rebuttals to the 30th of August, and we're no longer holding hearing sessions on the 29th of September. And other than that, everything remains as is. What I will probably do though is give the appellant slightly longer to put the memory sticks together and send them out. Just if you're getting documents and hearing statements on the 9th, they'll just give a bit more time to deal with that, to reflect the pushing back of that date. But other than that, I think there's no other changes, but I'll put that in the note of the meeting. So item 8, any other business? So I will start with the appellant.
Nothing else to raise unless Mr. Elder has any last points to make.
Okay, thank you. Mr. Finlay?
No, nothing from Nature Scott or Highland Council.
Kelly?
No, nothing else to raise, ma'am.
And Ms. Bundy?
No, nothing else, thank you.
Okay, thank you. That's been really helpful and really useful for me. And thank you all for taking part and giving your time. I will circulate the notes meeting early next week because obviously the information is coming in on the 21st, so we'll have that every Monday. It can go out, and it'll also be published on our website. So I will now formally close the meeting. Again, thank you, and you can you're free to leave.
Thank you.
Cheerio.